things, and we'll go back to some other issues later. But I think we'll start with some of the questions on tape, and this one is you've spoken out on this one, but this one got a lot of British Columbians angry. Here with a question about the case is Bill Tillman.
Allan Schoenborn murdered his 3 children and left them to be found by his ex-wife, one of the most vicious and really sick murders we've seen in British Columbia. And yet we found out this month that he was going to be released on escorted day passes from the mental hospital he's been in. How did this happen? How can anyone in the community accept that idea?
You spoke out on this one. I think you were as shocked as everyone.
Yeah, I was surprised to hear about it. First of all, it's a tragedy, and let's not lose sight of that. And there are people still today that are deeply affected by this personally, including the mother of the 3 children, Darcy. I had a chance to meet with her and her cousin for a couple of hours, I guess it was last week. And I'm a new father, and so I can't begin to imagine what it must be like for Darcy or for her friends and family. But I think there's at least two things we have to keep in mind. That for about 200 years, the courts have said, starting in England, that if someone's found to be mentally ill at the time that they've committed what otherwise is an offense, that if they're so mentally ill as not to fully appreciate the nature and quality of their acts, they are to not be treated as a criminal in the penal system, but to be moved to effectively a mental health system. Now, 200 years ago, there wasn't much of a mental health system. What that meant in practice 200 years ago is you were held in custody at the pleasure of His Majesty. And in fact, that practice basically carried on in Canada and in British Columbia right through the 1980s, because our legislation said you were to be held if you were found to have committed an offense but were mentally ill sufficiently at the time, or criminally insane was the phrase used at that time. You were to be held at the pleasure of the Lieutenant Governor.
Meaning until
basically cabinet got around to it.
Yeah.
And you can imagine how that worked. So there were people that were convicted of or found to have committed fairly minor offenses that spent many years languishing in detention. And when the Charter of Rights and Freedoms came into effect in Canada, one of the cases that worked its way up to the Supreme Court of Canada was a challenge to those provisions in the criminal code. It said basically people could be held till cabinet got around to it, even if they're mentally ill. And the Supreme Court of Canada, not surprisingly, found that to be a violation of the Charter of Rights and Freedoms. Parliament had to go back and revisit it. In 1992, the existing provisions, for the most part, mostly the regime we now have, came about in 1992 under a previous federal progressive conservative government. And what it says is once a person's been found criminally not responsible because of a mental illness, there are cases to be reviewed at least every 12 months by a review board, and each province must set up a review board. So although the provinces appoint the review boards, the rules they must follow are established in the criminal code, and there's many provisions, all buried within 672 of the criminal code. In looking at those provisions over the last couple of weeks, and even being mindful of the Charter of Rights limitations, I think there is room to move to add extra safety or precautions for the public, and for those most serious offenses, taking people's lives, serious sexual assault, violence against the person, I think we could revisit those criminal code provisions federally so that it's not an automatic review every 12 months, but perhaps every 3 or 5 years or earlier if the treating psychiatrist finds that there's been a material improvement in the person's health. That's the safeguard. So they're not just locked away forever. If there's been a material improvement, then you can file a report with the review board and get a hearing to see how substantial this change is and whether the public safety could be protected if the person's to be released on conditions or otherwise. But right now, Darcy Clark and her friends and family are facing the prospect of another review board hearing that must be held under the criminal code within the next 12 months. That's a treadmill that for victims can be a very daunting.
That every 12 months.
It's a very daunting thing.